Hi, it's Deborah. It's a new year. Happy New Year. And I wish you all that's good and positive and hope that only great things happen to you this year. In the interim, we're going to continue with our legal hints, and today we're talking about statements. I recently received a call from a client who was very excited because he'd finally managed to find a witness in a rather complex case that we're dealing with. However, he informed me of two things. One, the witness has stated that even though he was willing to provide written evidence, he would not be attending court. And two, he wanted my client to prepare the statement for him. So, two major problems here. The first is if you have a witness who is not willing to attend court, there's not a lot of point. However, there is a way around it because that evidence could be vital. So what I've said to my client is this: we must take down the witness evidence, and then if we can't persuade him to attend court, we're going to have to subpoena him. That is not the greatest of ways forward, because if somebody's subpoenaed, they're resentful, and if they're resentful, they're not necessarily going to make a good witness. But if the evidence he's providing is really good evidence, then you're going to have to take a view on it. So that's number one. Number two, for me, is more important. Not more important, but really serious. So he has stated that he wants my client to prepare the statement for him. He's not willing to speak to me so that I can have a chat with him so that I can prepare the statement for him, having taken down the what happened in his words. He wants the client to prepare the statement for him. This is potentially fatal. Don't do it. Don't ever do it. It just is not good practice. What you have to understand is this witness is going to attend at court and is going to be cross-examined. And if you have prepared the witness statement for him, so it's not from his memory or her memory, not from their experience, then really horrendous things can happen. So I'm just going to give you an example. A few years ago, I was contacted by a young woman who informed me that she had been offered £16,000 in a matter that she was dealing with. Her previous solicitors had informed her it was a good deal. I checked over the papers, it was a good deal. But she was determined that she wanted £85,000. That was what she was determined. She obtained witness statements from her colleagues at work. However, she wrote the witness statements. She turns up at trial. The witnesses are cross-examined. They don't remember. They didn't prepare the statement. Therefore, they had not a clue what was in it. Counsel decimated them. They were completely undermined. She lost the whole case. Not only did she lose the £16,000 that was offered, she then ended up with £60,000 in costs. So you preparing a statement on behalf of your witness is not a good idea. What should happen is simply this. Either you get your witness to speak to your legal representative, or you get your witness to put down their version of events in writing. That can then be sent to someone like me, who can go through it and go, oh, there's some information missing, can go back with a series of questions which can be answered by the witness. Preferably, it would be much better if the witness actually had a meeting with your legal representative and there was a back and forth of questions and answers, and all that information was put down. It was put into a formalised statement which they would then read carefully, make sure there were no mistakes, add anything they wanted to add, remove anything they wanted to add before they signed it. And then prior to the trial, you would send them a copy of that statement so that they can reread what they said at the time. That would be the most sensible way forward, not what my client is thinking of doing. Even when you've done all that, you need to be careful. Witness statements have to be in a certain format. And I think it's practice direction 52. I could be wrong. If I am, I'm going to put a little note at the bottom of this YouTube video. So it's practice direction 52, and it sets out for you clearly what has to be done. So when you do a witness statement, not only do you have to make sure you've put the person's full name, date of birth, their address, you also need to make reference to what employment they do. If they're unemployed, you just put down they're unemployed. It should be double line spacing, and each paragraph should be numbered. At the very end, there should be a statement of truth, which should be signed. Okay, and it should be signed by the witness. So if that isn't done, and if it isn't presented in the correct format, your witness's statement can be thrown out on a technicality, and it has recently been done in a couple of cases, just to let you know. So when you're preparing your statement, or when you're preparing a witness statement, please do make a note of these little points I've made, because they are rather important. In the meantime, I hope you have a brilliant and gorgeous day, and I hope these hints have helped a little bit. Bye!